So before we resume our second day of the Insecurity Conference, I wanted just once again to acknowledge that in Milwaukee, we are on traditional Potawatomi, Ho-Chunk, and Menominee homeland along the southwest shore and the human and non-human people of Wisconsin's sovereign Anishinaabe, Ho-Chunk, Menominee, Oneida, and Mohican nations remain present. Thanks. Before we get started today, it's my pleasure to introduce our Chancellor, Mark Monet. Mark is somebody who's no stranger to insecurity. He took over the position of Chancellor at a time when state support for the university system was arguably at its most critical and perhaps insecure in the history of Wisconsin. And as a scholar of downsizing organizations, I think Mark was in a unique position to guide UWM through those very insecure times. We are still afloat and moving forward, and Mark has good credit for that. So my pleasure to welcome Chancellor Monet.
Well, thanks, Richard. Good morning, everybody. Thank you for being here. And I will just take a few minutes in front of your keynote. I'm delighted to be here at the beginning of your first full day. I'm sorry I missed late yesterday. It sounds like a wonderful plenary and a great kickoff to an important conference. This summit is made possible by the remarkable faculty, staff, leadership, and students of our C21 Center. Please join me in thanking them for what they do in so many different areas. It's their commitment to research and educational excellence. So thank you, Richard. Thank you all. So I'm absolutely thrilled to be here. And as you know, this center is critical to UWM. It fosters interdisciplinary humanities research. It extends well beyond our city, state, and nation in many ways. C21 supports postdoctoral studies by way of grants, fellowships, opportunities for publications, and more. And this is quite important to us as a Research One university. Many of you probably know that we were re-established, recertified as a Research One institution this year after first being recognized as a Research One university in 2016. And this puts us in the top 131 universities out of 4,300 that contend for that in this country. So it's significant and important. What this standing does is confirms our role and how we address significant and important societal challenges, how we answer pressing issues, and how we create and disseminate new knowledge. It also shows the significant impact that such work has on the region and the world. It's something that you know, as experts in the field, the importance when we think about C21, your summit, how much we need to better understand and inform the world, and really about the human experience, which requires that intersectional approach. What I'm especially proud of, as I looked at the program, is how you're taking on insecurity, which is inarguably the array of issues of our time. As I think about insecurities, I think about a few different areas, and this is not by any means comprehensive, but I think most of these are addressed in some form or another in your conference. Food insecurity. Yesterday there was a report, I guess I have it back in my top of my stack there. Yesterday a report came out that documents how almost 50% of college students in this country experience food insecurity. What's particularly challenging about that is that white students are about 40% insecure. Black students are above 50. I'm sorry, Hispanic students are well above 50, and black students are almost 60%. So there's quite a range. There's quite a disparity, insecurity within insecurity. So there's different levels of this. Environmentally, as Professor Grusin pointed out, where we reside, where the rivers come together and on sacred ground, we're very sensitive about the environmental, ecological, and related insecurities of water. And this is something, as I continue to think about environmental impact, I think about the role, and I'll talk about this in a moment, of the Menominee Nation with respect to sustainable forestry practices, which are well documented and internationally well known, where people come from around the world to understand that. So we think that that's an important part of the answer, go back to the origins of humanity here. On the technological front, we have so many experiences that array from cyber to privacy to the cost to digital divide, so many different levels of cyber insecurity that we experience today on the technological front. In the financial, political, and global order, think if you're in Venezuela today, the Ukraine, Iran, with respect to what's occurring literally today. These are very insecure times. The national versus urban security, I love that theme and some of the different topics that are discussed, the tension in the name of national security that can drive urban insecurity, as well as when we think about our communities, our campuses, and other activities that have secondary and tertiary effects of different levels of security. And of course, identity, security, insecurity, that is all too common today. So your discussions underscore the role and the value of an educated citizenry. And I think about the political divides, and I think about the fractionization, the divides that exist, and I think about how education, especially the types of discussion that's occurring here, can help. And let me be more specific in terms of this. I'm really proud of the role of C21 in this conference to bring you together, internationally well-known and renowned scholars from the humanities, social sciences, arts, and other disciplines. That's where the power really lies, and we need that greater interdisciplinarity. We need the intellectual discourse because there's so much value in the critical thinking, deep analysis, and really alternatives. Think about alternative dispute resolution without the diverse views. Think about what limits we would have if we were so either binary or our way is the right way, which we unfortunately see all too often. So we have to turn that into problem solving and solutions that inform and drive policy. You've all heard the saying, what happens in Las Vegas stays in Las Vegas. And what I'd like to say, somewhat kiddingly, is let's not have what happens in Milwaukee at this conference stay in Milwaukee. Let me be even more serious about this and talk about the importance of curriculum change through this discourse, but also drive a policy change. If we can accomplish that, and if we can take this type of discourse into more serious levels of application and true problem solving, we've accomplished much more. Don't get me wrong, to advance discussion, to have what we can provide, and I thought about this a lot as I was preparing my comments. I thought about how fortunate we are to be able to have this type of conversation, to be able to have meaningful reflection and discourse, but there's so much important content. I think it's upon us, it's an obligation, and I challenge you to take this and really go beyond what just the discussions can be and really think about how do we drive this into curriculum? How do we have more impact? So that's my offer of provocation, if you will. Curriculum and policy change can be very powerful tools. So in closing, we're very proud to reflect and have this type of, these principles, this type of discussion really form the bedrock of what we do at UWM. It's just fundamental, it's foundational to everything we do. All our students get exposed to 60 credits of this type of exposure. So thank you again for joining us this week. Richard, back to you.
Thanks very much, Chancellor Mone. My name is Ann Bonds. I'm Associate Professor of Geography here at the University of Wisconsin-Milwaukee. And it's really, truly my distinct pleasure to introduce this morning's plenary speaker, Naomi Paik. She's an assistant professor of Asian American Studies at the University of Illinois, Urbana-Champaign. Naomi's research and teaching interests include comparative ethnic studies, U.S. imperialism, U.S. militarism, social and cultural approaches to legal studies, transnational and women of color feminists, feminisms, carceral spaces, and labor, race, and migration. She's the author of an extraordinary book called Rightlessness, Testimony, and Redress in U.S. Prison Camps Since World War II, which reads testimonial narratives of subjects rendered rightless by the U.S. state through their imprisonment in camps. The book has received high acclaim. In 2008, it was named the best book in history by the Asian American Studies Association. And in 2017, it was the runner-up for the John Hope Franklin Prize for Best Book in American Studies by the American Studies Association. Of the book, Paul Gilroy notes, quote, Paik's meticulous book opens up new interpretive approaches to fundamental problems of U.S. sovereignty and democracy. A challenging historical survey of the relationship between normal styles of government and states of emergency has been artfully combined with a bold defense of the value of rights in the struggles of the excluded, racialized, and incarcerated, end quote. This book is really critically important for understanding the intersections of American liberalism, carcerality, and empire. And the testimonies Naomi draws from to craft her argument are gripping and powerful. In addition to this book, she has published articles in Social Text, Radical History Review, Cultural Dynamics, Race and Class, Humanity, and the collection Guantanamo and American Empire. Naomi is a leading scholar on sanctuary and sanctuary movements. And at this critical juncture of expulsion and securitization, we have much to learn from her work. She is currently writing a book called Bans, Walls, Raids, Sanctuary, which is under contract with the University of California Press. And this is a short book that will focus on the criminalization of migrants in the US and radical sanctuary movements. As a board member of Radical History Review, she is co-editing 3 special issues of the journal, one on militarism and capitalism, which is due out winter 2019, Radical Histories of Sanctuary, which will come out fall 2019, and Policing, Justice, and Radical Imagination in spring 2020. She is also developing projects on the meaning of sanctuary for all and another on military outsourcing. So Naomi's talk this morning is entitled Deadly Entanglements, U.S. Imperialism and the Perils of Privatizing Security. Please join me in welcoming Naomi Paik.
All right, hello everyone, good morning. That was terrible. Hello everyone, good morning. Morning. Okay, thank you. Okay, so first of all, I want to thank Richard Grusin and the C21 organizing committee for inviting me here. I want to thank especially Maureen Ryan for coordinating all the details of our visit, or of my visit, and making it so easy to come here. And I want to thank all of you for being here. So like Ann said, I kind of switched up things. Like I was going to talk about sanctuary today, but I decided to switch to talk about the military outsourcing project. Basically, as I was finishing Rightlessness, I started working on this project on military outsourcing, and then November 2016 happened, and I was like, I just put that down and started doing all this other stuff, and that led me into the work on sanctuary. So I'm happy to talk about that during the Q&A, but I'm going to talk about something very different in this talk. I think my talk today will riff off some of the themes that were raised by Mark's plenary talk yesterday. I'm going to be talking about economic insecurity and the fact that millions of people around the world do not have the economic conditions of a viable life, of a livable life. And that ends up feeding the security interest or industry that can never actually achieve its goal, its purported goal, but does achieve the manufacture of death and corpses. So I'll be talking about that today. This is a really new project because I just got it going and then put it down. So I am really looking forward to questions about that. But again, I can talk about bans, walls, and raids as well. Okay. Okay. In August 2004, 13 men set out on the highway connecting Amman, Jordan, to Baghdad, Iraq. They had already journeyed many miles from Nepal. Recruited by a local company to work in a luxury hotel, they were instead passed up a chain of contractors that had other plans for them. Forced to relinquish their passports and held in a camp, they would work on a US military base in Iraq. But on the highway to the base, insurgents of the Ansar al-Sunnah army intercepted their unguarded convoy and assassinated 12 of them, broadcasting their killings on the internet. Only one man survived the journey. Narrowly escaping this brutal fate, Buddy Prasad Gurung worked for 15 months on the Al-Assad air base. Though he wanted to return home, the debt he accrued for the opportunity to work compelled him to stay. He and the workers' families have failed to find justice for the deaths of their loved ones, despite concerted efforts. While the insurgents committed these executions, the families also hold the US government and that chain of military contractors responsible for endangering the workers' lives in the first place. Even though KBR, a Houston-based corporation, and the US military employed the workers, a chain of contractors shielded them from liability. The workers' contracts precluded suing the government, so the families filed a civil lawsuit against the contractors. But in 2014, US federal courts threw out the case. I begin with these 13 men, and the justice denied them because they raised the major issues I grapple with in this new project on US military outsourcing, one that extends themes that I addressed in my previous work while asking questions in a related but new field of study for me. So in what follows, I'll briefly situate the history or the emergence of military outsourcing in two contexts. So first, its emergence from broader neoliberal shifts that have led the US government to sell away a central facet of its sovereign power. And second, its extension of imperial logics of race, gender, and labor revised under 21st century conditions. And finally, I'll return to this case of the 13 Nepalese men. By reading their lawsuit, Adhikari v. Daoud, I'll examine the ambiguous legal regimes that leave migrant military workers without recourse for catastrophic events like assassination and for more mundane abuses like debt bondage. As the Adhikari case shows, outsourcing military labor exploits the world's poorest in service of US imperial warfare in ways that strip them of rights and even of life, without the possibility of redress. So the use of civilian and non-citizen laborers to support military endeavors is neither new nor unique to the United States. Other imperial states employed colonized subjects as soldiers, and the US military has boosted its forces with foreign soldiers and civilian workers since the Revolutionary War. So this reliance deepened with US imperial expansion. For example, the US employed thousands of Filipino workers during the Spanish-American War and during World War II. And as scholars like Simeon Mann and Patrick Chung highlight, the US deployed neo-colonial relations to mobilize Asian workers and soldiers from South Korea, the Philippines, Southeast Asia, and the Pacific Islands during the Vietnam War. So while longstanding, military outsourcing has accelerated since the late 20th century, due in part to several important shifts: the termination of the draft and the move to the all-volunteer force, the end of the Cold War, and the launch of the War on Terror. So the end of conscription set crucial conditions for the growth of outsourcing. Since the US moved to an all-volunteer force, the military workforce has contracted by half, leading the military to fill workforce gaps with civilians. More important, the draft's end facilitated the transformation of military work from a gendered obligation of citizenship to a market relationship, a shift that occurred amid a broader political economic shift towards neoliberalism. Indeed, the Chicago School identified mandatory military service as the greatest intrusion of state power into citizens' freedom. In a 1966 report called The Draft, Milton Friedman argued, a voluntary army would preserve the freedom of individuals to serve or not to serve, and claimed that conscription leveraged an unfair draft tax on people who had better economic opportunities. Poor people who had a lower draft tax would choose to enlist voluntarily as economically rational actors. So this neoliberal logic converged with the anti-Vietnam War movement and resistance to the draft, leading to the end of conscription in 1973. However, neoliberal proponents were no anti-war advocates. They need broad-scale militarization to secure conditions for global capitalism. But as Deborah Cowan argues, the question of who provides defense, who pays for it, and who actually dies doing it are separate matters. So this shift to the all-volunteer force occurred in the context of free market reforms throughout the political economy, including deindustrialization, economic deregulation, privatization of public services, and the dismantling of the welfare state. These reforms exacerbated inequalities while destroying social safety nets for the people most vulnerable to the 1970s economic global recession. So while the military offered jobs to working class people with limited alternatives, it also provided the state with a pool of workers to supply its now all-volunteer force. Military service is defined less by the voluntary enlistment of rational actors, as Milton Friedman argued, than it is a force relying on a poverty or economic draft, as Maya Eichler states so well. Since conscription ended, the military's demographics have shifted, with overrepresentation of the poor and people of color from abandoned urban and rural communities. And these racial and class dynamics have globalized with the growth of outsourced labor. The end of the Cold War marked another crucial shift to the expansion of military outsourcing. Global conflict, concentrated largely between two superpowers, metastasized like a cancer into dispersed global threats that proved more varied and nimble. Armed conflict has increased since. But this increase has met with a downsizing of state militaries, flooding the global market with a large labor pool of ex-soldiers, as well as weapons and equipment. This combination of smaller state militaries with increased military deployments has created a robust market for military services. The private military industry rapidly expanded in the Cold War's aftermath. Corporations promote their ability to fulfill security needs on demand without governments needing to reserve a standing military. Outsourcing, whether of cooking and cleaning or killing, has stepped in as a seemingly efficient solution. As one CEO put it, you can't have huge standing armies. That is not efficient or economically feasible. You pay for the recruitment of soldiers, the training, sustainment, forever. Every 24 hours, he costs you money. Healthcare until he dies. A contractor, hire him for a special purpose and fire him. This flexible expendability has proven especially useful under the War on Terror, which incited global military spending not seen since World War II. Much of it funneled to military corporations. Contractors are embedded in nearly every aspect of military and security services today. The use of outsourced labor was so extensive in Iraq and Afghanistan that the contractor casualties outnumbered military casualties. As journalist Ron Nordland states, even dying is being outsourced here. This is the point, right? Outsourcing military labor achieves multiple political functions beyond increased efficiency. Shielded from FOIA requests and protected by proprietary laws, military corporations stand apart from public scrutiny and oversight agencies. By deploying privately employed workers, the US government can claim that it sends far fewer troops while using much larger workforces to execute its missions. In short, the use of private contractors obscures the size of US security forces and the extent of US military action. It impedes broader publics in the United States, in the countries where military contractors work, and the countries from which their labor is extracted, from even knowing how they participate in these networks of militarized labor. Military outsourcing enables the US public to divorce itself from its military engagements and to avoid considering who labors on behalf of its supposed security. So labor outsourcing spreads throughout the US security state. From Paul Bremer, who led the military occupation of Iraq, he was a contractor and he led the occupation, right? To former US soldiers who work security details, to locals who provide service work. However, third country nationals, or TCNs, those who are citizens neither of the country of their employer, like the United States, nor of the location of their employment, like Iraq, constitute a uniquely vulnerable class of workers. The US government prefers them over its own citizens, who cost more, and over local nationals, who purportedly pose greater security risks. Indeed, third country workers now comprise the largest and most diverse civilian workforce ever assembled in support of US military operations. The United States spends extraordinary amounts on military contracts, with tens of billions of dollars wasted through cost-plus contracts, cost-plus overages charged by the primary contractors like Halliburton or KBR. This is not like some new thing, right? Like even, political cartoons have talked about this extensively. So indeed, despite the claims of greater efficiency, the US Government Accountability Office reported that hiring contractors expends more than deploying military personnel. But these astounding expenditures do not trickle down to the workers. Although the US pays more than $65,000 per third country national worker annually, the worker himself receives only between $1,800 and $6,000 per year. So where does the money go? So between the government expenditure of $65,000 and the worker paycheck of around $2,000, a chain of local recruiters, subcontractors, and the prime contractor pocket tens of thousands. Furthermore, workers pay steep fees to local recruiters, often by incurring substantial debt. By setting up offices in locations of endemic poverty and desperate need for wages, contractor networks extract wealth not only from the US government, but also from workers themselves, sometimes secured through threats of violence to them and their families. Over 400 manpower agencies operate in Kathmandu alone, sending migrants to labor in homes, factories, hotels, World Cup construction projects, and US military bases. Although recruiters entice workers with promises of lucrative wages and prompt debt repayment, workers discover they receive much lower pay under worse conditions after they have borrowed the money and left the country. Once indebted, these migrant workers have little choice but to go wherever the employment chain sends them. As fraud investigator Sindhu Kavinamanil states, debt will make you work anywhere. So such relations of migration, labor, and debt, all under conditions of global inequalities of wealth, have deep roots in histories of empire and global capital. So some precedents that I'll just mention briefly here are the coolie system of Asian indentured laborers who overlapped with and eventually replaced slave labor in the 19th and 20th centuries under similar conditions of debt secured by long-term contracts. And I think we can also see braceros and H2 workers as being in a similar kind of labor chain, right? They're recruited to work in the US to work on agriculture and seasonal contracts. But they are tied to specific employers. If they leave that employer, they become undocumented and deportable, right? So the legal system of migration operates as a disciplinary function around work and labor extraction. So the US government's hiring of TCNs elaborates on such systems of exploitative labor migration. It draws on long histories that cross the globe and on more recent networks specific to the political economy of the Persian Gulf, which has supplied its labor markets with Asian workers since the 1970s oil boom. Not only has the US military moved towards this new center of gravity in the Middle East since World War II, but its shift to outsourced labor draws on these pre-existing transnational labor supply chains. So if we're gonna get real about military labor migration, then we have to look at these supply chains first, right? Which is not just about US military imperialism, but is about a whole global system based on the extraction of the poorest people, right? Okay, so military outsourcing also draws on imperial discourses of race and gender that match certain populations for particular kinds of work. So while military corporations recruit so-called martial races and conflict labor for violence work, right, like combat and interrogation, other feminized racial groups are designated for labor like cooking and laundry. So rooted in imperial efforts to manage colonized subjects and the 19th century scientific theories of race that supported those efforts, the category of so-called martial races constructs certain populations, like Gurkhas and Sikhs, as innately aggressive and suited for combat. I am not saying that Gurkhas and Sikhs are naturally suited for combat. I'm saying this is a really messed up imperial discourse that then gets leveraged by these corporations, right? Okay, so these racial constructions of militarized masculinity become renovated under neoliberal capital for use by the military corporations that commodify their bodies and their labor power for sale. So these corporations also recruit conflict labor produced by recent histories of militarized violence. These include Ugandan ex-soldiers, former special forces officers from Bosnia, and police who worked under the Pinochet regime of Chile. Indeed, Latin America has provided a particularly fertile recruiting ground. Contractors view these veterans as adeptly suited for interrogation and counterinsurgency operations. As former Chilean political prisoner Tito Tricot states, what should be a national shame turns into a market asset due to the privatization of the Iraq War. In contrast to these racialized, militarized masculinities, other racial categories are recruited to perform reproductive or menial labor, and this dichotomy again reflects colonial discourses. For example, while Gurkhas serve in armed functions, other kinds of Nepalis, like the Adhikari plaintiffs, largely labor in unskilled service work, which had been previously fulfilled by US servicemen. But once the draft ended, these support services became increasingly performed by civilian workers. And outsourcing has further relegated devalued and feminized labor largely to racialized workers of the global South. And this restructuring of military labor also performs ideological work for the US military. By establishing a clear line of distinction against foreign workers, outsourcing serves to consolidate unity among US soldiers, a highly segmented and hierarchical workforce with poor people of color generally filling its lowest ranks. Put differently, outsourcing not only fills direct needs for labor, but also strengthens bonds of unity amongst US soldiers who are in fact divided by disparities of class, race, gender, sexuality, and citizenship. As Isabel Barker argues, the social operation of homogenizing a we by way of contrast with a them permeates all imperial projects. So regardless of the type of labor they perform, outsourced TCN workers earn far less than their US counterparts. Their underpaid exploitation undergirds the entire military outsourcing industry. And yet some governments support their citizens' work for military corporations due to the lucrative remittances they send home, even as their wages decline as the labor market becomes saturated. So both employers and sending countries then participate in the commodification of colonial, racial, and gendered logics, as well as recent histories of armed conflict. Military corporations also cut costs by spending as little as possible for the workers' sustenance, while extracting maximum labor from them. Contractors warehouse workers in man camps, reported to be unfit for human habitation, lacking temperature control, adequate bathing and bathroom facilities, food quantities, and sufficient space for each occupant. As one worker asserted, they treated us like animals. Workers cannot move freely or leave the man camps, which are surrounded by armed guards, purportedly for their own safety. This virtual lockdown ultimately confines the workers in a carceral space. An anonymous KBR employee testified, "I don't know if they're trying to keep people in or keep people out. There probably is no more secure place on the base than the Indian camp. I can go anywhere on the base, but I can't go there." This combination of exploitation and confinement has led to worker uprisings. For example, more than 1,000 workers erupted in a food riot in May 2010, one eventually contained by other outsourced workers, Ugandan security guards. So both groups of foreign workers found themselves in Iraq through the migrant labor systems that profit off their exploitation. And yet they're being pitted against each other obscures those shared conditions. And it is these labor systems that shield corporations and the military from regulation or accountability, even when they lead to violence and even to death. So the Adhikari plaintiffs, the 12 men assassinated by insurgents and the survivor, Buddy Prasang Gurung, traveled to work for the US military through utterly typical pathways. Recruited, hired, and employed by the contractor chain I just explained that ends with the US military. So recruiters of Moonlight Consulting promised them monthly earnings of $500 for working at a luxury hotel in Amman, Jordan. Once they incurred their substantial debt, the men then transferred to Amman under Morningstar Recruitment and Manpower Supply, which had long hired South and Southeast Asian workers to work in Jordan. They were then kept as captives, as Gurung stated, in a room so dark they were unable to see by Dawood and partners, which confiscated their passports and ordered them to work not in a hotel, but on the Al-Assad air base for 3/4 of their promised pay. Though they wanted to return home after hearing that they were going to be in a conflict zone, they were compelled to proceed to Iraq because of the debts they and their families had to pay the brokers. Dawood then transported the men into Iraq in an unguarded caravan that traveled on the Amman to Baghdad highway, widely recognized as highly dangerous with significant risks. So as noted, the Ansar al-Sunnah army intercepted the first 2 vehicles of the convoy, kidnapped the plaintiffs, and publicly circulated their message on YouTube. It broadcast the brutal executions of the 12 men, one by beheading, the others by gunshot to the back of the head. Nepalis rioted in Kathmandu after seeing the video, directing their fury against Moonlight Consulting and other recruiters, as well as the offices of Qatar Airways, Gulf Air, and other carriers. And the facts of this case seem exceptional because of the extraordinary brutality of these executions. But the facts themselves are not exceptional. These men traveled to work for the US military in Iraq through entirely standard practices. Right? And third country national workers are well understood to be the soft underbelly of the US presence in Iraq. Different insurgent groups had kidnapped and murdered migrant military workers from Turkey, Pakistan, Indonesia, Egypt, Bulgaria, and Kenya prior to this event. So insurgents targeted such workers as US collaborators to interrupt US military labor chains and to intimidate governments into stopping their citizens from providing this crucial support to the US military. Indeed, the Nepalese government had already barred recruiters from sending its citizens to Iraq. But once a recruiter delivers workers up the contractor chain, it purportedly cannot control where they end up. But what does distinguish the Adhikari plaintiffs from other migrant military workers is that they brought a legal case to US federal courts at all. This usually does not happen, right? The highly public, lurid violence of their deaths brought heightened attention to their case. So legal advocates fought on their behalf, winning their families death benefits of $300 per month through the Defense Base Act and the War Hazards Compensation Act, which are the only 2 labor laws that applied to third country national workers. But this unwieldy and protracted process excludes most workers, who must prove they were employed by the US government and document the injury when it occurred. So while the Adhikari survivors have found at least this marginal compensation, they share with other workers the limits and even futility of looking to the law for redress. As third country nationals, they fall in a unique position. Citizens neither of the United States nor the territory of their work, employed through a contractor chain, working on foreign occupied territory. They thus fall into jurisdictional crevices created by the patchwork of laws that could, but ultimately do not ensure their legal recognition. So what court ultimately had jurisdiction over this case? The event occurred in Iraq, with Nepali plaintiffs suing US and Jordanian defendants who were not the direct employers or recruiters of the workers in US courts. So Iraqi courts lacked jurisdiction. The rules of the US military occupation gave contractors legal immunity, right? Explicitly prohibiting the Iraqi judiciary from prosecuting any contractor. US military courts lacked jurisdiction. The Uniform Code for Military Justice covers US service personnel, not civilian contractors. And most US laws, including labor laws, do not extend beyond US borders. In the words of one high-ranking contracting officer, Labor law doesn't exist here. The Defense Department denied all liability, asserting the government had no jurisdiction over this case. It essentially followed through on the promise of outsourcing, deploying the contractor chain to shield itself, even as its demand for cheap labor endangered the workers to begin with. International law has also proved limited in recognizing these workers' rights. As Daryl Lee notes, because third country nationals follow between parties to the conflict and civilians, they have an ambiguous relationship to the laws of war and to international laws that protect migrant workers. Furthermore, the US has refused to join the International Criminal Court, blocking US citizens from its jurisdiction. So this complex patchwork of legal regimes has left third country nationals in what the ACLU calls a jurisdictional black hole or a legal Bermuda Triangle. And despite this black hole that seemingly crushes the rights and recognition of third country nationals, the workers' lawyers brought the Adhikari case to the federal court based on recent laws that explicitly extended beyond US territory and innovative interpretations of the Alien Tort Statute that stretched its territorial reach. So basically we had new laws that extended beyond US borders and a new interpretation of a very old law that also extended its interpretation beyond US borders. And so these are recent developments that then these lawyers deployed, right? Okay, so District Judge Keith Ellison had to decide this central question. What specific circumstances could trigger the court's recognition of claims that occurred beyond the United States? So the Adhikari case offered a test case of how the judiciary would recognize the extraterritorial claims commonly found in systems of US military outsourcing, but novel to the court's consideration. So the case emerged within a broader context of shifting questions, judicial interpretations, and legislation concerning the applicability of US laws beyond its borders. The judiciary has relied on an overriding presumption against extraterritorial application of federal law, meaning that courts must assume US laws apply only in the United States. But this presumption is not absolute, however, as courts have had to grapple with the transnational crossings of capital, people, goods, and ideas, including discourses of human rights. Congress has also had to deal with quandaries over jurisdictional gaps stemming from the presumption against extraterritoriality. It passed the Trafficking Victims Protection Act and the Military Extraterritorial Jurisdiction Act, or MAJA, in 2000 to cover these gaps. And the Adhikari case used these two laws to bring a case to federal court. So the Trafficking Act enables civil lawsuits and criminal prosecution for trafficking crimes. And the MAJA extends the jurisdiction of US courts beyond its borders to cover felonies committed by civilians accompanying the military. So in fact, Congress passed these two laws partly in response to the misdeeds of civilian contractors. In 1999, employees of the military corporation DynCorp were caught operating a sex trafficking ring while working under a US contract in Bosnia, right? So these laws were kind of triggered by the problems that are induced by military contracting. However, as Judge Ellison noted, these national laws with transnational jurisdiction remain a relatively murky area of the law, and regulations enforcements against the crimes they prohibit are scarce. Federal regulations against trafficking among contractors, for example, rely entirely on self-reporting and carry no enforcement mechanisms. They're essentially symbolic gestures. So we're like, depending on DynCorp to say, hey, like we caught some of our guys like operating sex trafficking ring, you should punish us, right? That's the logic behind these laws. Okay, so not only does this predicament reflect the widespread problems of human rights enforcement, which have no enforcement mechanisms behind them, it also highlights the paradox of looking to the state to regulate an industry it relies on to execute its missions. The US military cannot operate with military corporations and thus lacks incentive to enforce regulations over them. The Justice Department rarely brings such cases to courts. In 2011, the House of Representatives found that not a single case of human trafficking, sexual assault, wage theft, or related crimes has been prosecuted by the Justice Department, and only a single case has ever been referred to for prosecution by the Defense Department. In fact, the Adhikari case is the first case testing the applicability of the Trafficking Act against US contractors in Iraq and leverages only civil claims against KBR and Dawood since the Justice Department would not file criminal charges. So lawyers fought for Adhikari, seeking to use US courts as venues to redress human rights violations that are fundamentally not contained by US borders. However, when the demands of the state and human rights conflict, the state has ultimately decided in favor of its own interests, right? This is entirely unsurprising. This is the foundational paradox of human rights law. As Nehal Bhuta argues, international law and its sources remained resolutely statist, and indeed the working presumption of human rights law was that it would best be realized through a well-functioning and powerful state apparatus. So adjudicating human rights in state-based courts can succeed only when the needs of both align. This is like Derek Bell's theory of interest convergence, right? So over the course of litigation between 2009 and 2015, Judge Ellison ultimately dismissed all charges, he noted, with wholehearted sympathy to the victims. His dismissal marked a shift from his earliest opinions that favored an extraterritorial analysis and of the workers. In previous orders, Ellison focused on the violation of trafficking more than the limits of US jurisdiction, noting that a defendant chose to commit a criminal act in a location where this court may not have jurisdiction does not alter the criminality of the act itself, right? So he was looking more at the actual thing that happened rather than the bounds of his jurisdiction. Furthermore, because human trafficking is by nature an international crime, he reasoned, placing territorial limits on US jurisdiction would contravene the clear purpose of the Trafficking Act and would inappropriately absolve those who could in fact be guilty of violating its provisions. Ellison initially argued that trafficking and forced labor do violate the law of nations. He further reasoned that Dawood had established enough contacts with the United States to grant the court jurisdiction, even as a foreign corporation acting beyond US territory. Indeed, he noted, Dawood obtained 100% of its business from US entities. However, the turning point of the case came in 2013, following a crucial Supreme Court decision. In Kiobel v. Royal Dutch Petroleum, former residents of the Niger Delta sued corporations for aiding the Nigerian military's brutal repression of communities that protested the environmental destruction wrought by oil extraction, including killings, arbitrary detention, and torture. Kiobel posed the central question of whether the court has the authority to recognize a cause of action under US law to enforce a norm of international law. The Supreme Court decided the court did not, right? So the Supreme Court decided that the US cannot decide a norm of international law, that they were two separate things, right? But while not closing the door entirely on the court's jurisdiction, it ruled that its claims must touch and concern the territory of the United States with sufficient force to displace the presumption against extraterritorial application. Okay, so while explicitly deciding that mere corporate presence fails to meet this condition, the sufficient force standard is utterly vague, leaving the lower courts to interpret what precisely fulfills this requirement. So you can't just have a mere corporate presence in the United States to trigger extraterritorial jurisdiction, but there is some wiggle room around what could meet this standard. So the decision affirms the court's opposition to extraterritorial jurisdiction and largely lifts the threat of liability for US corporations. So based on Kiobel about the Nigerian Delta, right, Ellison overturned his initial orders, deciding that the Adhikari claims did not touch US territory with sufficient force. The claims against Dawood in particular matched precisely what Kiobel seeks to bar, since they are foreign cubed, with a foreign plaintiff suing a foreign defendant for a violation that occurred on foreign territory. Yet, as Ellison noted previously, Dawood had more than a mere corporate presence in the United States. By receiving 100% of its business from US entities, Dawood worked directly and indirectly for US corporations and the US government. Ellison further dismissed the contact the Adhikari workers would have had on a US base where they would arguably arguably be touching US territory, right? Because the Al-Assad Air Base is considered US territory, murkily, but kind of, right? Because they were assassinated before they made it to the base. So he's like, if they made it to the base, then we would have extraterritorial jurisdiction, but since they were murdered on the way, it doesn't count. Right? Okay, so because the defendant must be present in the United States to bring claims to US courts, Dawood could not be held accountable. And because KBR was not the direct employer of the plaintiffs, nor the direct perpetrator of the trafficking violations, it could not be held liable either. As Lee cogently argues, those who are most directly responsible for third country national labor conditions can evade jurisdiction while the ultimate beneficiaries of those conditions can readily demonstrate ignorance of them. Indeed, Judge Ellison acknowledged, each man was deceived about, sorry, I'm gonna go back, okay. Indeed, as Ellison acknowledged, each man was promised a hotel-related job in Jordan. Each man's family took on significant debt in order to pay recruitment fees. When the men arrived in Jordan, they were subject to threats and harm. Their passports were confiscated, and the men were locked into a compound and threatened. So despite his profound regret for the victims, he holds no one accountable for the violations he describes as more vile than anything the court has previously confronted. Even his passive, this is it, okay. So even his passive description of the crimes lacks any actors. The men were harmed, but there was no one inflicting the harm, and thus no one to hold responsible. Okay, so a lot of us are teachers, and I imagine a lot of us have to teach writing classes or writing intensive. I use passages like this to talk about the perils of passive voice, and like that I'm not just being annoying and circling all there is, are, was, were verbs, but that it actually has political and ideological implications when we cannot understand who's doing what, especially when there's actual like victims involved, okay? Okay, so in throwing out the entire case, all claims against both KBR and Dawood, Ellison, in his own former words, inappropriately absolved those who in fact could be guilty. So my reading of Adhikari v. Dawood offers a brief view of the questions I'm working through around broad issues of imperialism, race and gender, capital and labor, legal regimes, and neoliberal governance. The case shows how legal regimes have not kept pace with the far-reaching tentacles of transnational warfare, labor, migration, and capital flows. It reveals how US military outsourcing maneuvers in legal gray zones between civilian and military law, private and public interests, and national and international jurisdictions in ways that threaten democracy itself. The case further highlights the difficulty of limiting our critique to existing legal structures of redress and accountability. So on the one hand, the Trafficking Act offered one of few ways to make claims against the contractors that endangered the Adhikari plaintiffs' lives. But on the other hand, as we know from criticisms of carceral feminism, the Trafficking Act also operates through a punitive logic of criminalization that conflicts with abolitionist, liberationist political commitments. Indeed, the Trafficking Act fails to do what it sets out to do, right, as this Adhikari case shows. But what the Trafficking Act does do is contribute to the militarization of borders that criminalizes the movements of migrants and renders them more vulnerable to smugglers. And we can see this happening on the US-Mexico border right now. So we are still separating parents from children, or adults from children at the US-Mexico border. How are we doing this in spite of Trump's "I'm gonna set the babies free" like executive order? We're doing it by accusing the adults of trafficking children. Okay, and that's how we kidnap children from the families that they come here with. So it's like a weaponization of a tool that's supposed to be meant for actual victims of trafficking, right? That is being deployed against regular migrants. So we have to have like this abolitionist frame if we're going to get real about military migrant labor and migrant labor in general. Okay. So instead of focusing on a narrowly conceived problem of trafficking, I want to broaden our frame of analysis and dismantle the foundational causes of forced migration to begin with. The structural conditions of global inequality and dire poverty that led Adhikari, Gurung, and so many others to voluntarily choose to submit themselves to debt peonage, whether at the US military base, a World Cup stadium, or an oil field. It's these roots of forced migration that punitive instruments that the Trafficking Act cannot address. On a deeper level, Adhikari indicates how, when the state sells away a core component of its sovereignty by outsourcing military work, it also eviscerates the ground for democratic governance. By transferring authority, public funds, and oversight to private corporations, military outsourcing obstructs varying publics from even knowing how they enable and participate in lethal networks of militarized violence. It contributes to the hollowing out of democratic conditions, including the people's orientation toward the public good and their ability to discern the ways of power, history, representation, and justice, as Wendy Brown argues. Indeed, as a senator, Barack Obama, on the one hand, I miss him under current conditions. On the other hand, I am not a fan, right? Whose administration oversaw the expansion of military outsourcing, forewarned. This is when he was a senator before he became president. You are eroding the core of our military's relationship to the nation and how accountability is structured. I think you are privatizing something that is what essentially sets a nation state apart, which is a monopoly on violence. And to set those kinds of precedents, I think, will lead us over the long term into some troubled waters, which he did. He led us into these troubled waters. Okay, as Obama suggests here, the momentum towards military outsourcing presents the challenge of resisting affirming state authority, military power, and the state's monopoly over violence, while also opposing the relinquishment of these powers from the state, which at least has some kind of semblance of democratic control and public responsibility, to corporate capital, which has none. So I'm always like on the one hand, on the other hand, I'm kind of like always shuffling back and forth. So on the one hand, it's not like I'm saying the state ever had or actually should have a monopoly on violence, that the U.S. sovereign state actually should be deploying military, its own citizens as military members to execute its imperial ambitions abroad. I am not saying that, but I'm saying what we're seeing right now, I think is more dangerous, okay? So this is one of the problems that I'm grappling with, and I invite people to help me. Okay, so I don't want to shore up the state and say that it should have a monopoly over violence. And we know what the state does when it executes this monopoly over violence, right? Policing, prisons, warfare, surveillance, border securitization, and so on. And so what I want to get to is a world without militarized violence at all, right? But in the meantime, I want to curtail the proliferation of military and security corporations that moves us further from that goal, right? Since they profit from and thus depend on violent conflict for their very survival. So as states and other entities empower private corporations to deploy violence for profit, these deadly entanglements lead us into the troubled waters of increased insecurity all around the globe, with no pretense of checks and balances over those threatening capacities. While those rendered so vulnerable by military outsourcing, like the Adhikari plaintiffs, suffer the effects immediately, they forewarn of a shared future where no one's security can be assured. Thank you. Excuse me. Yeah.
Just a quick note about the use of the microphones. Also, I know some people were kind of not sure whether to use them. There's two reasons we use the microphones. One is for the live stream because the talks are being recorded. And the other is for accessibility for people who have trouble hearing. So please do use the microphones to ask your questions. They're very easy. If they don't seem to be working, flip the switch up to turn it on. Thank you. That's all.
Okay, question for Naomi.
Thank you for that stellar presentation. It was very, very interesting. I have a couple of comments and some questions. You spoke about extraterritorial jurisdiction and the challenges in accessing defendants who are on foreign soil. I'm an attorney, and I can tell you that in a number of areas of law, for example, in issues involving, say, cyber warfare, when you have a foreign national, just to take an example, shall we say, a Chinese guy sitting in Brazil and launching cyber attack on the United States systems, well, there are legal mechanisms for obtaining jurisdiction over this person. Likewise, the law has been creatively used to obtain jurisdiction over defendants who are involved in disturbing acts of pedophilia, for instance, on foreign soil. Now, the point I'm trying to make is that if the judge had applied her mind to the facts of the case and had shown some forensic ingenuity, she could have made a convincing case for establishing liability and jurisdiction.
Yep.
But the larger issue here is that the law has always been, and the justice system too, they have always been handmaidens
Yeah.
of powers that be.
Yeah.
Recall a celebrated or infamous case, depending on your perspective, going back to the Second World War, Korematsu v. United States. Fred Korematsu was a Japanese American. He was interned. Justice Felix Frankfurter upheld his internment. Much later, after he quit office, he expressed regret over his decision. So we have a long history where the law has abdicated its responsibility at a crucial time. But that does not mean that the legal hardware is not available to bring people to justice. The other point I have to make is...
Just make sure we have time for more questions.
Okay, we'll stop here.
Yeah.
Ask the next question.
Should we stack questions or?
Yeah,
should-
can we do it?
Yeah.
Does that work? Rachel, do you want to submit your question?
Go ahead and stack.
I'll take your question and one more over here. So if you want to go, Rachel?
I need the names of speaking.
Sorry, I was forgetting the key microphone.
Thanks, Naomi. That was a really interesting talk. This is more of a comment than a question, but I think of the McCarran-Walter Act as kind of presaging a lot of this question of extraterritoriality. Like in 1952, they kind of see it. You know, we're going to have an empire. What does it mean when people do stuff around the empire? And a lot, they do litigate or set jurisprudence in McCarran-Walter for some of these questions. I mean, I don't think McCarran was much of a visionary at all, but I wonder if you've gone back to that or if it's useful.
Okay.
And I guess the comment is, I think it might be useful.
Okay. Thank you.
Thanks, Rachel. Right here.
Thank you, Naomi. I had a question about the other half of, let's say, or maybe the other part of this contracting force, which is there a way to theorize the outsourcing of to things like academica or Zed or Blackwater, or whatever, in your framework, right? Because I think something I read suggested that estimates of the actual frontline fighting force in Iraq was something like 50% outsourced, which is huge, if that's true. So I'm curious if there's a way to kind of, I know you mentioned some of the ways that racial logics play into like killers, and so I'm just sort of curious to hear a little bit more if you've thought about that and if you could comment on that. Thank you.
Okay. Okay, cool. So I'll start with Rachel's because this one's the easiest. Is like I haven't looked specifically at the McCarran-Walter Act to help me with this, but I totally will now that you've mentioned it, because I do think that this is a pivotal moment in not only migration history but also the U.S. in the world's in its global kind of ambitions. Right? It's kind of like this pivotal moment, and so I think it would be really useful for me to go back to that. So thank you very much for that. So the first question about extraterritorial jurisdiction. Yes, I agree with you. I think the law, I mean, this is one of the things where I'm always like on the one hand, on the other hand, right? Because like on the one hand, I don't trust the state at all or its legal apparatus at all because it has never been here for like many of us, okay? Like you can't say that the US state and its constitution, right, and the laws that are drawn on the constitution have ever been really here for people like the Adhikari plaintiffs, right? You can't say that when it legitimized and constitutionalized slave labor. So like it actually was like slave labor cool. Like if you want to get your slave back when they escape to freedom, go get him, right? So I do not want to affirm or shore up like any confidence in the state and that this was a failure of the law. I think the law was doing what it does. Having said that, I think we need to pull every lever that we can. Right? And the law, like legal cases, the courts, passing new legislation, getting like the police to end the gang database, like there's a whole array of things that are levers of the state that we need to pull, right? At the same time, so I agree that filing these kinds of lawsuits and I don't want to abandon this whole set of tools that can actually work towards liberationist goals. I just don't want to misidentify recognition by the law as being some kind of horizon of justice. Does that make sense? Okay, so it's like in the meantime, until we get to this, the future that I want to see, like I'm like we should sue everyone we can. You know what I'm saying? Okay. The other thing is that, okay, so first of all, the judge is a man. So if he could have used his legal ingenuity, I completely agree, right? And he was actually doing that earlier on in the case when it was first filed. It's really after this Kiobel versus Dutch Petroleum case by the Supreme Court that he was like, well, this new precedent has come down and I have to follow the Supreme Court's precedent. So it's not just about Judge Keith Ellison, who's a district court, which is like the lowest level court. It's also about the Supreme Court and them shoring up, being like, well, you know, we can't really hold this European corporation responsible for things that the Nigerian military did, even though they kind of put up the Nigerian military up to do this, you know? So it's like, I think it's, and this is why I have no real faith in the courts, even though I still think we need to go to the courts. Because the other thing about going to the courts is discovery. And especially when we're talking about like corporations, discovery is really important. Even when, you know, to the public, a lot of it is redacted, like you get some sheets and the whole thing is blacked out, right? It's still important that you make the corporation show something, especially when the whole point of the corporation is to show nothing, right? And so I think the discovery process is really important. Any kind of testimonies that get into the court record from those Nigerian community members who were tortured, murdered, expelled, whatever, right? That is an important record, even though it didn't lead to a winning case, right? So I think that these levers of the law, we have to use them in creative ways, when we have to use them all the time, right? And I think the Korematsu case actually brings up an interesting one, right? So the Korematsu case was actually officially repealed recently. Does anyone know where? So Korematsu has been binding legal precedent since World War II until last year. Who knows which case? It's the Muslim ban. When the Supreme Court affirmed the legitimacy and constitutionality of the Muslim ban, they were like, but we really don't like this comparison that Sonia Sotomayor is making to Korematsu, so we're just taking Korematsu off the table. We're officially delegitimizing as precedent the Korematsu case as we affirm the legitimacy of the Muslim ban. So what is going on with that, right? So this again, you know, it's like this stuff is complicated, which is why I'm always going like this, because like if we lived in a binary world, it would make things so much easier. Yeah. Oh yes, and Eric. Okay, so Yes, I was planning, like, a couple years ago when I started this, I was thinking about Blackwater. Having said that, I feel like Blackwater, when you say military contractor, kind of takes all the air out of the room, when in fact, most of contracting in the US military is mostly through logistics. It's less through combat, it's mostly through logistics. So I think we have to look at logistics, and logistics itself being not only innovated and developed through US militarism, largely through World War II and the Vietnam War. I mean, in this Radical History Review, which I edited, there's an article by Patrick Chung that talks about the rise of the Hanjin Corporation and the rise of military outsourcing and the rise of logistics through the Vietnam War. Right? And so it's developed and innovated through US militarism, but then has become this, like, you cannot have global capitalism without these large logistics kind of networks, right? So I think it's really important to look at logistics in addition to the kind of deployment of privatized violence workers, right? So I was thinking about looking at Blackwater through, oh my God, now the case is escaping me. It's Blackwater security detail that like ended up massacring people in Iraq in Nisour Square. I forget the name of the case though, but they actually got convicted on the first round. I think it's been overturned lately. So I'm like, okay, so how is it that US citizens actually were convicted, right, in US courts, when it seems like Blackwater is the most kind of like shielded in a certain way? And, so I wanted to think about the complications around that case, but yeah, I haven't thought about it in like 4 years, so yeah.
I'll stack questions again, so Annie, come over here. Yep, start with Annie.
That was like such an amazing and illuminating act of cognitive mapping that if you don't have anything to say about this, that's totally fine because you had so much to say already. But I'm just curious about, because like toward the very end, I like the connection that you're making between military and non-military outsourcing and the sort of problems that OFWs in general pose to questions of justice, exploitation, jurisdiction, et cetera. But I'm just curious about whether the contracting agencies, I don't know if the manpower that's doing the military outsourcing is the same as the manpower that's the world's largest non-digital temp agency. Okay. But I'm just curious. What'd you say? Based here in Milwaukee, that's right, yeah. So I'm just curious about whether or not like the massive OFW labor force working in things like domestic work and construction is materially, as opposed to just analogically connected to the military networks. Mm-hmm. And then also what I'm just curious about, like thinking about these like places like the Philippines where the remittance economy makes up such a huge portion of the overall economy, like what portion of those of the remittance economy in places like that is specifically from military as opposed to non-military labor outsourcing. Mm-hmm. So just curious.
Yes, and thank you for your talk. It was fantastic. But also, so my question / comment has to do with rights, and I'm struggling. I guess many of us may be struggling with the same questions. So on the one hand, as you point out correctly, right, we cannot trust the state or these rights. And I didn't know that trafficking norms are being used to legitimize the separation. So thank you for that detail too. But then on the other hand, you said, well, we should sue as much as we can, right? And I agree with that too. But then you also mentioned something about abolitionism, and you've been already talking about that since yesterday. So I was wondering, because one more added thing, I'm originally from Argentina, so I grew up also with this notion that, human rights are important because they were important for us.
Yeah.
But there's all these complications, and so we may be using rights to sue as much as we can to give visibility and all the things you said, but then the same instruments we're using are being used to do things such as family separations. Uh-huh. And so how does if anything, is there any abolitionist position in regards of rights? I would like to hear more.
Yes. Thank you. I'm so excited for this question. Okay.
Do we want to do one more in keeping with this, or do you want to?
I can just go.
Okay.
Okay. Okay, so Annie's question, yes. It's not just analogical, it's the same agencies. So the same agencies that send workers to die building World Cup stadiums in, is it Qatar? In Qatar, same agency, same recruiter chain until the last like kind of nodule of the recruiter chain that's KBR and the US military. And actually KBR is a logistics company. It is not necessarily a military outsourcing company. It got its start in oil extraction, right? So like, again, in this fabulous issue of RHR, there's another article in there about the strange career of Donald Rumsfeld, which talks about how Halliburton got its start in oil extraction and then, becomes like a military outsourcing company because it stopped selling its ability to extract oil because that became less profitable, and it starts selling its services as a logistics operator, right? Okay, so but yeah, it's the same chain. And that's what I'm saying. If we're gonna get real about military migrant labor, then we gotta get real about this chain that sends military or like any kind of worker all over, right? For all kinds of industries. Right? So we have to get real about that and the root causes of labor migrations. Military migrant labor migrations are still labor migrations, right? Okay, so this other one, yes, okay, so about rights. So in that book, I talk a lot about rights and how I'm like, on the one hand, rights are a problem because rights also contain within them and need rightlessness. Rights don't make sense without the rightless. And so as long as we're operating in a liberal democratic framework of rights, we're always gonna have rightless people, right? And so we need to kind of like reconceive how our relationships to each other that are, that don't depend on rights and that don't depend on notions of things like citizenship as determining my relationality to the people around me, right? On the other hand, rights are what we have right now, right? So you're absolutely right. It's not like I want to say human rights are unimportant or because they're tainted, we just shouldn't use them. Like you can't, if you're living in the world that we actually live in, then you can't have those kind of purist politics and actually get anything done, right? You can just be on Twitter and like criticizing everyone, but you don't actually get anything done, right? So human rights are an important tool, right? At the same time, like I responded to the first question, I just don't want to misidentify a rights recognition as liberation or as like building the world that we actually want right now. But they're really important to people who are subject to these labor migration chains, who are living in these kind of manpower camps, who are like still living in Guantanamo, right? Who are in, solitary confinement. The language of rights is very powerful. People understand somewhat what I'm talking about if you just drop the word human rights, and I think that is useful. And so we have to use that again as a tool. Right? But if I'm trying to think about an abolitionist view of like, what is it that I actually want? An abolitionist redress that is for real would be like KBR and Dawood and the US military not just stopping using migrant military labor, it would also be investing in local economies in Kathmandu, and building schools instead of like sucking out labor from Kathmandu, but like investing in the place. And whatever industries make sense for that location. It could be green energy. I don't even know. But like doctors, hospitals, teachers, things like this. You create employment and the conditions to have a livable life so that workers don't think that my only way in order to obtain a livable life is to leave this place into debt bondage. Right? So that would be an abolitionist kind of redress in my mind, right? So yeah, I know that's not gonna happen, but that's like my goal, dream, something, yeah.
As everyone else said, fascinating and deeply disturbing talk. And it's really hard to wrap our heads around it. I have just a minor, question or observation for you. You mentioned democracy in positive terms in your talk, and I wonder some of the slippage that we are seeing, is happening precisely because democratic politics is so nationalistic, and democratic constitutional state is responsible only for its citizens. And you kind of mentioned that citizenship itself becomes a problem, because then it allows people in the borderlands and in in places where the jurisdiction doesn't apply. But even, immigration in general kind of renationalizes politics, and that's the kind of conundrum or dilemma or paradox of democracy in some ways. So how do you see democracy versus this kind of global, movement of people and labor?
I join everyone else in thanking you and being super blown away by what you're offering us. I want to ask you a question about Milton Friedman and the sort of debt bondage of the other side of the coin. So like when I'm working with the sort of outsourcing of the military in the early 90s, I'm thinking about what it means for the overrepresentation of Black men and Latinx men to be sent to the Middle East to do the work of empire, the real killing. And so I'm wondering how, given your rich work on the carceral, like how we can think with what's happening at home as well as abroad in the context of the debt bondage of service positioned specifically by Friedman as choice, right? The choice to enter.
I have a kind of on the one hand, on the other hand, to your on the one hand, on the other hand, and this is not well articulated, but I'm going to try. So on the one hand, I think that I think this was such a wonderful talk because of the way that you inhabit that difficulty without resolving the one and the other hand. On the other hand, I wonder whether your being placed in that position is part of the logic that's at work here. Because we might leverage the gray areas, but one of the things that you're pointing out is that the gray area is precisely what allows the logic to work in the first place. And that's about it. I don't know what to do with that, but because I agree. I think that had you not inhabited the sort of difficult space, this wouldn't have been the kind of mapping that it was. But inhabiting that space seems to be exactly the position that is sort of structuring the whole.
Yeah. Oh, these are really hard questions. What is democracy? Okay. Okay, I'm going to go in reverse order. Okay, so on the one hand, so you're exactly right. So on the one hand, like these gray areas, I'm interested in these gray areas where like the laws of the state are ambiguous, or like where the reach of capital is like a little bit ambiguous, like these kind of gray areas like maroon communities, things like this. I'm really interested in that as being like, what kind of creative spaces, what kind of creative new lines of affiliation and relationality among people, among resources, what happens in those kinds of spaces, right? On the other hand, these like kind of gray spaces and gray zones are actually really useful for the state and capital. Like like Guantanamo is purportedly a legal gray zone that the U.S. is like, cool. It's like beyond the Constitution, it's beyond Cuban law, it's beyond international law. We can use this for our advantage, right? And so I think these gray zones are not inherently liberationist, and they're not inherently purveyors of violence. It's how they get deployed and who's doing the deploying and for what purposes. So yeah, I think that's exactly right. That this kind of like, I'm always kind of shuffling between different kinds of thinking is part. I think you're totally right in that it's identifying the very problem that we're trying to grapple with, right? Okay. I think that's a really great point about trying to think through this kind of over-deployment, or like the voluntary right enlistment not of U.S. soldiers in the United States as citizens through like the regular kind of recruiting channels, as well as the voluntary volunteering for debt bondage in other places. And I think I do need to do a better job of like bringing those two things together. But I think they do operate within a similar logic, which Milton Friedman, theorized, right? That it shouldn't be like military service should not be an obligation of citizenship, but that it should be a market marketized, right? It should be a market value. So your value to the country becomes like about, when you enlist, you get a $40,000 bonus as soon as you enlist, and that you get certain kinds of benefits, right? And so I do think, though, that as it gets outsourced, first of all, it's making the military labor pool even more diverse, not only because it's pulling from beyond the United States, but in terms of like ethnicity, language, like all this kind of stuff, it's getting much more diverse, right? And I think also one of the dangers of making it a market relationship is that the market is becoming increasingly saturated, which is also driving down wages even further, even for labor that is life risking, like even for the military work, like the actual violence workers, like the wages are going down because there's so many people who are willing to enlist to do this kind of work. And so I still think we need to look at the underlying political economy that's supporting this whole system, right? And I think that's where we can see the shared ground between US Black and Latinx men going through becoming army soldiers or whatever, and then these outsourced military workers. Okay, and then democracy. Okay, so yes, I think you're absolutely right. On the one hand, like I'm saying that there's an de-democratization going on that we can identify quite clearly in military outsourcing. I do not define democracy as being completely hinged and tied to a nation-state framework. I think of democracy as power of the people, like decision-making shared by people, right? And this is getting to the other project on sanctuary a little bit, where I talk about how sanctuary, there's a kind of fundamental opposition to sovereignty, the sovereign state, right? And I think that I would like to see a democratic kind of political vision that is not reliant or tied to a nation-state framework, that is really more about affiliation and relationality among the people in a shared communion, however that whatever the boundaries of that communion should be. And it should also be about relationships not only to each other as people, but to resources and to land. And I think that is how we can redefine what democracy could actually look like, but it really takes a lot of work to unlearn how we've been so conditioned to think that like voting is democracy, or that representative democracy actually is democracy, because I don't think that's what it is, right?
We think of democracy without the state, stateless democracy.
Kind of, yeah.
No one has authority over violence or monopoly over violence. Who's going to reinforce? Who's going to enforce it?
Yeah, so this is like the first clapback to any abolitionist position all the time. What are you gonna do? Like, it's gonna be anarchy and chaos. Right, so like you really, when I'm talking about the ground up, I'm being real, like you're thinking the ground is here. I'm like, no, man, we gotta go subterranean with this. You gotta find like the bedrock and build from there. Right? So like, that's what I'm saying. And I feel like, okay, for any kind of political project that we're invested in, like not having migrant military labor, we still have to have some kind of vision of what the horizon is, what the goal is. And then we also have to have kind of political tests about, is this a good strategy or not? And I think having this like, kind of really, and you might think it's like pie in the sky and it's like never gonna work and it's just gonna be chaos, and what about the murderers and the rapists and like whatever, right? But if we don't have a clear vision of what we actually want, then we're gonna end up going with like kind of liberal Band-Aid goals that actually make things worse, like the Trafficking Act. You get me? So I mean, I know that it seems like wild, like some of the stuff that I'm proposing, like a democracy without a state and a monopoly of violence. But it's like, I think that actually is the goal. Hey, Richard?
Thanks, that was just really brilliant. I want to pick up on your last remarks and also the question you asked about violence and should the state have a monopoly on violence?
Uh-huh.
And so what I was first thinking is, well, maybe it should, but it should be extraordinarily heavily regulated.
Uh-huh.
But the other option is, as you were just talking about democracy and the people, is maybe the people need to have a monopoly on violence. And that's in a way what you were suggesting is raised as, of course, the terrifying image of anarchy and so on and so forth. But it seems to me that I'm not sure I'm advocating this, but it seems to me that's a logical conclusion or a logical assumption. The other question or point I just wanted to make from another angle is also in a way picking up on what you were saying about the ground, that it seems to me that these changes need to happen not only through, as you were saying, like these transnational companies creating livable conditions all over the world and so forth, but actually not just from them changing. We need to create these kinds of non-human practices of living that aren't sort of provided for us by corporations making things livable, but that change comes about when the ways in which we live on a daily basis, the way in which we get our food, get our sociality, et cetera, changes. And so that's not a satisfactory answer. It's not a sexy answer because it takes kind of a lot of time. But so neither of these are just sort of solutions necessarily, but last thing to say is what I really admire about your position is the way you are trying simultaneously to hold a kind of utopian abolitionist point of view and a recognition that we need to use whatever means are necessary in the meantime. And I think that that's difficult, but at this point, perhaps the only way forward that one could see in the at least near term. So.
We're short on time. So I think we're actually technically a little over, so maybe. Oh, sorry. Okay, sorry. I'm eating into your break. Okay, so just really quickly. Okay, this is the other thing. I realize that right now, saying that a state should not have a monopoly over violence is actually the case in parts of the world, and it's not good. It's really, really not good. It's really, really bad. And so I'm not saying the world should be like that, right? I'm saying that we have to earn the right to get to the place where we don't have states having a monopoly over violence, right? Which means that we have to fundamentally change the way we relate to each other. We have to fundamentally change our ways of living, our habitus. We cannot go forward with the way that we have established our relationships to each other right now, right? And that is the radical reimagining that is required. What else? Yeah. I guess I would say that. I would say that. I would say that what the world that I want to get to is a world where we don't allow institutions like nation states to dictate how we relate to each other and how we relate to the land around us and how we relate to other people's land as well. I want to get to the place where we establish our relationships and accountability to each other. Where the only thing that matters to me is that because we live in a globalized networked world, I have a certain kind of accountability to everyone that I'm connected to, which is actually a lot of people. And that I am accountable to them and they're accountable to me. I would rather have that be the basis of our relationships to each other than being like, well, you're a citizen, so I'm gonna think that I have some kind of connection to you. You know what I'm saying? So that's the kind of vision that I want to see. Okay, yay! Okay, good.